Good afternoon, everyone. It is noon, so we are going to get started with our November. I can't believe it's November already. Our November in the boardroom topic this month is County Regulation of Short-Term Rentals, Part 2. I'm Sarah Diedrich Kasdorf, the Director of Outreach and Member Engagement at the Wisconsin Counties Association. I will serve as your de facto host this afternoon. I have just a few quick announcements before we get into our webinar for today. First, as always, if you have any questions during this webinar, please feel free to use either the chat or the Q&A feature, which can be found on the lower portion of your Zoom screen. I will monitor the chat and the Q&A throughout the presentation. I'm sure Rebecca and Malia will as well. So as time permits, we will take questions as they come in. Otherwise, we will take questions at the end of today's presentation. The second thing I just want to mention, I know we get asked this every month as well. Will this be recorded and posted on the WCA website? And the answer to both of those questions is yes. We are currently recording this webinar, and the PowerPoint presentation will be placed on our website along with the recording shortly after we complete our webinar today. You'll find that at www.wicounties.org. And then in the upper right-hand corner of the website, which is the quickest way to find it, there is a button called WCA Webinars. Click on that. That will take you to our In the Boardroom series. So with that, I'm going to turn it over to Rebecca and Malia. For those of you who joined us back in August, you may recall we had a lovely discussion with Rebecca and Malia with regard to county regulation of short-term rentals. We also continued the discussion at our September annual conference. There is so much material to cover that we needed to go to a part 2 on this particular topic. So the PowerPoint, I believe, is going to be the same as it was in August. We are just going to start midway through or so with a little bit of a recap. So Rebecca Roker, Malia Malone from Attolles Law, again, they're back to assist us in understanding what counties can do with regard to short-term rentals. So I don't know who's starting, Malia or Rebecca?
Well, I'll start because it looks like Rebecca is muted.
Oh,
I don't, are you muted?
um, can you hear me?
Yes, now I can.
Okay. So I'm going to start, Malia. Yay. Um, Good afternoon, everyone. As Sarah so perfectly recapped, Sarah, thank you for the introduction. We are here today as a continuation of our In the Boardroom from August on short-term rentals. And as Sarah indicated, there is such a volume of information that we are at a great breaking point from our where we left off in August and where we are going to pick up today. So we are going to do, again, just a very short recap, and then pick up in the great stuff of what may a county regulate. What can y'all do with respect to short-term rental regulation? Malia, anything to add before we get rolling?
No, just that I don't think I was a part of the discussion in August. I think I had intended to be, and then we got separated. And so I think Rebecca's going to give a brief overview of sort of what she went through previously, and then we'll both dive in as we go forward, making it through the rest of the information we have for you.
Thank you, Malia. And you're correct. I forgot that I remember you were pulled away last minute. Um, but Malia did help and do a lot of the PowerPoint presentations. And we're going to get to your sections today, so that's perfect. All right, so with that, we'll get rolling. Let's see. Can y'all see my screen? Leah, can you see that? Okay,
Yep.
perfect. So what we covered last time is we did a pretty deep dive into the statutory overview, because all of those elements lay the foundation of what a county can regulate, right? Because a county may only regulate what we have statutory authority to regulate. So it's really important to have a working understanding of what those statutory restrictions are on counties when we're regulating short-term rentals. And then with all of that, it leads us to the question of what can the county regulate? So I am going to jump through these slides that we went through in August. And again, if there's any questions regarding the previous information or any of the statutory authority elements, feel free to put that question in the chat. And oops, I went too far. We will answer those as we go. And you see that the title slide is "Phew, what can a county regulate?" And that's exactly what the phew is, because there is so much background information from a statutory standpoint and an administrative code standpoint that we really have to work through in order to get to the clear answer of what may a county regulate. So with that, I think it's a fair statement to say that most counties want to, the top goal is to minimize or eliminate the impacts that result from short-term rentals. The ones that we hear most frequently from counties are set forth in the PowerPoint: noise, lots of vehicles because you've got renters and their guests. So where are they parking? Are they parking on streets? Garbage and other refuse, not only on the parcel, but also surrounding areas. Is there litter or other waste flowing into other people's yards? Impacts on natural resources. When we have a short-term rental, let's just say near one of our state's beautiful bodies of water, what is the impact of that increased use and that increased occupancy on the lake? How does um, that short-term use of 1 week multiplied over the course of several weeks, how does that one property impact our natural resources? And then probably the most frequent concern is the change of neighborhood character. We hear the question, why can't we regulate these? Because it's like a business. It doesn't matter that they're in a residential area. Somebody has brought a business that is the short-term rental that's not owner occupied to our neighborhood. Why can't we regulate it like a commercial operation? Because it's changing our neighborhood character. And that's a really complex question. So the argument that we've heard from organizations like the Realtors, and Malia has in the trenches experience on that in Polk County, is that we don't need new ordinances because there are state laws and existing ordinances in place. In terms of existing county ordinances, many of you have noise regulations. Many of you have disturbing the peace or disorderly conduct ordinances, or law enforcement can look to the state statutes for disorderly conduct. Why isn't that enough? Why do we have to adopt new regulations? Well, here's why. Because those existing regulations really do not address the full scope of the impact that short-term rentals have on our counties. Number one, given the number of short-term rentals you may have in your county, if it's a high number, that is going to be a tremendous burden on law enforcement. And obviously, we always need to be mindful of the burden on law enforcement and how we can make sure we utilize those resources in the best manner. But then also there's a lack of deterrent on the renters. So even if law enforcement, addresses the issue and issues a citation under an existing ordinance, many renters have said, well, we don't care. I mean, okay, we're getting a ticket, we're leaving on Sunday. What do we care? So it's not an efficient strategy to rely on the existing legal tools that we have in terms of disorderly conduct, and those types of laws. So we want to look for a more efficient mechanism of regulation. Malia, I'm going to pause here. Anything to jump in on or
Well,
anything
we're
to
really talking about the tragedy of the commons. So I mean, when we're looking at counties that have a lot of short-term rentals, especially as Rebecca said, on bodies of water, and they're constantly turning over, the impact on the natural resources, the kids out on jet skis that are creating wakes in places that normally wouldn't have wakes. I mean, all of the disturbances. So you want the benefit of the economic impact that the short-term rentals bring to counties, but you also wanting to minimize the impact, and that's sort of where we're trying to find that balance.
Malia, you hit on a great point of the excess wake. We know of these wake boats are an issue that counties face, and it's increasing because the technology and the availability of wake boats is increasing. And there are specific statutory restrictions on how a county or whether a county may have wake boat regulations. So that discussion of wake boats certainly fits into the discussion of short-term rentals. So that's a great point. All right. So what is the tool by which a county may regulate short-term rentals? The most frequent is a zoning ordinance that a county will utilize its zoning powers under Chapter 59 to require the owner or operator, maybe owner and operator, to secure a permit with the county. Some counties choose to do it at an administrative level, where it's a operational permit or just some sort of land use permit that does not require additional committee review and approval. Some counties take it to the next level and require a conditional use or a special use permit for that short-term rental. The benefit of that regulation is let's just say it's your zoning committee. Your zoning committee can take a deep dive into the impacts that need to be addressed and offset by that short-term rental. However, if we're regulating by zoning and requiring a conditional use permit, obviously we have to comply with all of the restrictions that come with a conditional use permit, such as we must have substantial evidence for the conditions. We have to look to measurable data. And obviously the applicant is provided a threshold of rights too. And so again, that's a whole other in the room on conditional use permits, but oftentimes counties do choose the conditional use permit as the tool to regulate short-term rentals. Another option that is available, it's not a frequently used option, but I think it's a really creative option, is the licensing ordinance. And this evolved as part of a county's work as acting as a DATCP agent. So many of you out there, your counties do act as DATCP agents for inspections and so forth. So what a county will do is take that work and that inspection work and then adopt a licensing ordinance for a short-term rental that piggybacks off of that work. So the goal is for an applicant, it's a pretty seamless process. And then the license is issued by your health department rather than by your zoning department. So again, there is a ease from an administration standpoint. Another reason being, depending on the number of short-term rentals you have in your county, your zoning office may not have the capability to handle that many, particularly if your county wants to use a conditional use permit as the regulatory mechanism. Some counties have hundreds of short-term rentals within their county. And does your zoning committee or your planning committee want to have to review hundreds of short-term rental conditional use permits? Probably not. So again, the licensing ordinance is a unique option that can address all of those unique circumstances in your county. Want to touch on the Wildwood Estate case here because it's a pending case, and I'm going to turn it over to Malia. But what's great about this case is it specifically looks at a licensing ordinance and gives us some direction on whether that licensing ordinance is a zoning ordinance. And this becomes important, as you may remember this Weevelhofer case, gives us some guidelines of, hey, whoa, you are doing a zoning ordinance. If you do a zoning ordinance, you have to have a higher level of protection of property rights. And so there is a greater legal scrutiny on a zoning ordinance. So, Malia, I'm going to kick it over to you so you can talk about, the key items in this case, and then also to help us differentiate between a zoning ordinance and a licensing ordinance.
Sure. So in this particular case, the county adopted an ordinance, called it a licensing ordinance, but ultimately the court found that the elements that the regulation addressed bled into land use regulation, and said because it bleeds into land use, it was really a zoning ordinance masquerading as a licensing ordinance. And because of that, it overturned the application of the ordinance because it had not gone through the appropriate process to adopt or amend a zoning ordinance. In other words, they didn't have a public hearing. They didn't take all the steps to notify folks of a public hearing, so input could be had, and therefore they could not use that ordinance to regulate short-term rentals because it was a zoning ordinance that had not been passed properly. And so when we're looking at a licensing ordinance, you have to make sure then you're really only addressing the issues that you can address as the DATCAP agent. In other words, as the health department going in and making sure all of those regulations are being followed, but not then also tack into it land use regulations. Setbacks, that kind of thing, things that would normally be a part of a zoning ordinance. And so if you're going to go the licensing route rather than a zoning ordinance, and it doesn't mean you can't do both. I mean, I think a county can certainly have both options. So there'd be a licensing component and a zoning component, but then ensuring that the counties go through the process and have your corp councils review any proposed ordinance to make sure that it meets the elements of a true licensing ordinance rather than zoning. Because I can tell you as a former corporation counsel, there's nothing worse than hearing that a particular ordinance is being addressed at the committee level and being passed on to county board, and it had not gone through corp council. So for the benefit of all the in-house county corporation councils out there, if you're working on any ordinance to address short-term rentals, whether it be a zoning ordinance or whether you believe it's purely a licensing ordinance, please clue in your county's corporation counsel. And as always, they are welcome to reach out to either me or to Rebecca so that we can help them review it. We're absolutely willing to assist corp counsels in that. But if you don't, then you could end up in the same place as the Village of Summit and have your ordinance overturned by a court, and that's a real bummer.
Mm-hmm. So we have a question, Jamie Selland. Do you have to be a DATCAP agent in order to adopt a licensing ordinance? Great question, and the answer is no. It often will see a licensing ordinance in conjunction with the DATCAP agency, because the work is so similar that it can be done in lockstep. But no, you do not have to be a DATCAP agent in order to have a licensing ordinance. So great question. Just to do a quick follow-up on the Wildwood Estate case, you may have towns within your county who express a desire to adopt a short-term rental ordinance. We know that depending on what they're doing, now we're getting into a discussion of town and county zoning. If a town's ordinance looks like a zoning ordinance or is adopted as a zoning ordinance, that raises a whole other set of issues for your zoning departments. So just be mindful of those if within your county there are towns that want to step in and specifically regulate short-term rentals and what those impacts on the county may be. All right. So our key point is whatever ordinance you adopt, whatever that tool of regulation is, you should have a well-reasoned, thorough, and legally compliant ordinance. And I will echo what Malia said, work with your corporation counsel, work with your zoning team, your health department team, get all those experts at the table so you can have a good baseline of what that ordinance is going to look like. All right.
Right. If you're going on the purely licensing administrative ordinance, you're looking at things like inspections and requiring that license and contact requirements. But if your ordinance is regulating things like when and where a short-term rental can operate, what districts are labeled, any of those things that kind of go, "Ooh, this is zoning," it's likely going to be seen as a zoning ordinance. So even if you've got both of those tied into the ordinance, better safe than sorry, always have a public hearing. You don't have to have a public hearing on a licensing ordinance, but when in doubt, have a hearing. Because it's simply gathering more public input. And even though ultimately it might not be required, it can save you from ending up in a position where you're trying to defend an ordinance as a licensing ordinance. If you have the public hearing and have all the other processes in place, then you're covered.
Yeah, great point, Malia. It never is a bad thing to have those extra process protections in place. So, all right, now we're going to go back to what may a county regulate? And there's really a short, easy answer, kind of. Anything not inconsistent with state law. So any county ordinance is always subject to preemption, whether there is a state or federal regulation regulating the same topic, a county may be preempted or trumped in that regulation. And we do not have the threshold of preemption that we see in other areas of the law. For example, large-scale solar regulation. That state law says counties, nope, you only have this little sliver of authority, and that's it. We've got more authority here. Is so long as our regulation is not inconsistent with the limitations on municipal regulation. So that's pretty clear, which is good. And again, the theory of preemption, I won't go through all these, but the takeaway is if there is a state law in place that addresses the same topic, the same scope, or there is a statute in place that withdraws your ability to regulate as a county, that's the preemption argument. Most of the case law we see on preemption, there's no clear answer. So a court will go through this 4-factor test to determine whether a topic is preempted. And then we also take our analysis through, but also beyond the right to rent law. And in this analysis, that's where we get into those due process considerations that Malia touched on. And what we look to what that underlying regulatory mechanism is and what due process accompanies that regulatory mechanism. All right. So what are some of the easy ones? What I call the low-hanging fruit that really there's no question that counties are safe to regulate, again, within the scope permitted by the law. So what are some of those low-hanging fruits? The duration. Counties may prohibit short-term rentals that are less than 7 days and prohibit rentals for more than 180 days within a consecutive 365-day period. This generates from the right to rent law. And Malia, I'm going to kind of kick it to you since you are our house expert on right to rent. But we're pretty certain, right, Malia, that we know that this is what counties can regulate from a duration standpoint, right?
Correct. So if counties have enacted an ordinance consistent with the right to rent law, and in other words, has those mandatory minimums in there, that short-term rentals must be for at least 7 days or longer. In other words, no Saturday, Sunday night, no 2-day rentals, that kind of thing. Counties can say the minimum amount you can rent for is 7 days or more. And then the 180 days that Rebecca talked about, consecutive 180 days, but the county cannot say where that 180 days needs to start and end. And this becomes a compliance issue on the ground, because if the counties can't say when that 180 days can run, how do they know when the 180 days start? So if it's a conditional use, perhaps there's a condition in there that the the owner of a short-term rental, somehow informs the county zoning department that, hey, we started April 2nd, and so start our 180 clock. But that's a whole administrative burden to those offices, trying to then be the repository for all of these, and then my apologies, complaints that come in if folks are renting. I apologize. I'm going to kick it
No,
to
that's
Rebecca.
okay. I'll take it back. Tis the season for those coughs. So duration, we've got some pretty good certainty, so that's a low-hanging fruit. Other low-hanging fruits, garbage receptacles, the number of garbage receptacles and when that garbage needs to be removed. Again, all within a reasonable standard. If we say, renter has to, or a owner has to contract with a private waste disposal, and they need to come every day, and you need to have a dumpster size receptacle. That's probably not reasonable. But general garbage receptacle and removals ordinances, we think those are pretty secure. We can do those. Building requirements, such as smoke detectors, fire extinguishers, and exit points, and here's the key, that are consistent with ATCP 72. So ATPC 72 is from the Wisconsin Administrative Code, and that is what DACCAP looks to as the baseline regulation for short-term rentals. So if a county wants to adopt similar or mirror image restrictions on smoke detectors, fire extinguishers, and exit points, you can do so. Loose dogs and animals unattended. This is one that I've heard quite a bit from counties. The renter brings their family dog. Family dog is super excited. There's a lake, and takes off running across the neighbor's yard, because that's what some dogs do. So this is one that is, again, one of those quality of life issues for the neighbors. May not have a significant impact on, our natural resources per se, but again, it's a quality of life issue, and something that, those neighbors have to endure for weeks at a time. So a county can most likely adopt, that a loose dog regulation. House rules posted indoors on the premises. You see these often if you've ever used a VRBO. There'll be house rules on the fridge. Those are fine. An owner or agent contact for the renters, but also for the neighbors. So if there is a dog running loose, who can that neighbor call rather than calling law enforcement? I think it is a fair statement that many owners, many renters want to do the right thing. They want to be good neighbors. They want to, blend in with the community and allow people who are renting to come and enjoy that community for a short period of time. And a ordinance requiring that contact is a really good step in an owner showing that they want to be a good neighbor. So it's certainly something that you can build into your ordinance. I will say, and we're going to talk about where that point of contact is located. Some of those points might be questionable. So if you say the point of contact has to be within 5 minutes of the property, nah, that's most likely not permissible. But just having an owner or agent contact for the renters of the property and the neighbors is fine. A ordinance requirement that the owner comply with the tax laws or any other applicable laws, that's fine. On an application requiring a site plan, floor plan, parking plan, or other general plan information, we think that's fine too. That's a low-hanging fruit that you can require just to have that illustration of what the layout is for that short-term rental. So what are some of the regulations that are likely fine, more questionable? Property insurance. Now we said that property insurance, at a baseline is reasonable. But when a county looks to extraordinary amounts, that's when it gets a little questionable. Similar with other types of uses that counties may be regulating. I'll use solar again because that's a hot topic. If we're requiring $100 billion of insurance, that's probably not reasonable and it's not going to pass the smell test. So your ordinance most likely can require insurance, but again, in reasonable amounts. Proof of registration or proof of registration compliance with sales tax and other tax requirements. So as short-term rentals have to do reporting to the Department of Revenue, have a clause in your ordinance that requires compliance and proof of compliance if asked or at the time of application. Parking regulations, again, most likely fine, as long as they're reasonable. We don't recommend counties have no on-street parking for short-term rental requirements. Why? Because you are now distinguishing that short-term rental use from the other neighbor's use. And that's where we have to be very careful in our regulations. We can't, in some circumstances, we can't treat those short-term rentals different than we do other residential users. That's one of our oldest short-term rental cases in the law and the rule that we have to follow. So you can ask for, or you can most likely ask for a reasonable parking plan to show where folks are going to be parking on the premises. And then they can incorporate the on-street parking provisions or account for no on-street parking as long as those are universal. Avoid an ordinance that says short-term renters cannot park on the street if other people can park on the street. Proof of homeowner association or condo association approval. This is one that gets a little bit sticky because sure, it makes sense that you as the county would want to know that an underlying HOA or condo association has given the thumbs up on this use. However, if we're making it a requirement, we have to be very careful that it's not some sort of interference in the owner's contractual relationship or other relationship with either that HOA or condo association. So just be careful when you have those types of regulations that they don't go too far. And again, don't impinge upon other owner contractual rights.
Right. We don't want the county to become at least looked upon as sort of this governmental entity that's trying to enforce the private covenants that might exist because of those HOA requirements. So it's really just providing the county with a document, but in no way then acting as an agent or trying to enforce the private covenant through the county's regulation.
Mm-hmm. Yeah, great point. Another element on this point is regulating the number of short-term rentals within a particular area, such as within a subdivision that has an HOA or more likely in a condominium that has an association. Many condominiums, for all intents and purposes, look like apartments. Or in many of our northern counties, you will have the good old-fashioned resorts that have individual cabins that have now been condotized. And there may be a desire to limit the number of rentals in that area. If it's a condominium association, you have to be very careful because there's state law prohibitions on regulating a condominium as a particular use. And so condominium, the Wisconsin courts have said, nope, that is not a use. It is a form of ownership. And so you can't call out a condominium under your zoning ordinance as a unique mechanism of regulation. So be careful on those. No, I just want to check. Nope, no questions. Let's see. Back to the owner or agent representative within a reasonable distance. Most likely, it's fine, but just be reasonable in the distance. Look at, the layout of your county where there's a heavy concentration of those short-term rentals. Is it in the far, southern corner of your county or the southern part of the county? But, a greater population is in the northern part. Let's say those are 30 minutes apiece. If you start requiring somebody within 5 minutes, that might be questionable. So again, look at the big picture and look at what's reasonable. Maintaining the record of occupants, that's also most likely reasonable. That would be like the ledger, the rental ledger. Where it could get questionable is whether the owner has to report all of that information back to the county on a regular basis, or as part of your application materials. That could raise some concerns. Quiet hours in reasonable timeframes is also most likely fine. Again, that word reasonable, because again, one of those quality of life for neighbors and members of our communities, it's reasonable that, there's not going to be rock concerts going on at 2 in the morning. As much as we want people to enjoy the short summer months in Wisconsin, quiet hours is a reasonable ask. And then last one, no outdoor advertising on rental property. This is most likely fine because, again, we look at the use, which many will say is a commercial use, but we can't regulate it as that. However, that outside signage is an impact that is different from the underlying use of staying at a residence. So if your regulation is crafted in such a way that it's narrow and essentially says no outdoor advertising, other than a sign that says, Malia's rental, that should be fine. And I think, do we have a question? Yep, question from Kurt Hawkins. Would it be reasonable to require an existing home in the flood fringe of the floodplain that now wants a CUP to operate a TRH to elevate the structure to floodplain standards as a reasonable condition of a CUP? Great question. I think if we are in your proposed rental is in the floodplain, the first question I would ask is, are you requiring other residences to comply with those heightened standards? If not, this is where we get into an issue under the Heath Realty case. Are we treating these short-term rentals as a different type of use simply because they are short-term rentals? That court case tells us the use is housing people. The duration shouldn't matter. Again, and that goes against so much of our common sense. Just given the volume of people in a short-term rental and the fact that they're coming in and out. So again, back to the Kurt's question, I would say yes, but look at whether you can have those heightened thresholds within the floodplain apply to other other owners or other users, and not just what I will say targeting that the short-term rental use. That's where we're going to have an issue.
Now, if I'm just kind of thinking that question to its logical extreme, if there were a circumstance where through the application for a conditional use permit to operate the short-term rental, it became evident that a fix needed to be had because of actual safety concerns. So where, a part of the building was falling, and, if you've got lots of folks going in and out of a particular part, it's going to be dangerous. And the cost is not so extreme that it would operate as a complete prohibition on operating a short-term rental. In that case, I think in narrow circumstances, as a zoning committee or planning committee is looking at a CUP, they can take into account those unique things that might impact health and safety and place that condition on it outside, and not worry as much about the concern that, you're not applying the use because the use is housing people, because the only reason it came to light is because of an inspection after the application, that kind of thing. So I do think in narrow circumstances, depending upon the facts, you could craft a condition when it comes specifically to safety, health and safety.
Yeah, and that's a great point. And, Malia used those very important words of the health, if the regulation addresses a health and safety concern. So utilizing that threshold of police power. And that's really where you hone in on what is the impact of the use and what are we trying to mitigate by protecting the health, welfare, and safety. So if your county has particular issues that you need to regulate that kind of use aspect, then we just need to go a deeper dive into what are the impacts on the health, safety, and welfare, and how are we mitigating those in the ordinance. Another question from Charlie Handy: is it appropriate to require them, I think you mean the owners, to hang a long-term placard that we give to them that identifies the permit number and the county reporting contact info? So question is a permanent placard on I would assume you mean the outside of the property. This one I have a big problem with. And I know that some counties do it, but I have concerns that when we require a short-term rental to have that permanent notice outside that it's a short-term rental and what that permit number is, and most likely you'll have an owner agent number as well, then you are calling out that short-term rental. We're kind of putting a scarlet letter on it, or that could be how it's interpreted. And now we are regulating the use differently, which is, again, prohibited under the Heath Realty case. We found a middle ground on those placards. Some county, or one county I know of, will require the placard while there are renters there. It requires somebody to have access to the site, to place the placard there during those times of rentals. That's a better option. But to have a blanket requirement of that placard, I would encourage you to proceed with caution. Okay, let's jump to our more questionable. Now we get to Heath Realty in more detail. Prohibiting short-term rentals in residential districts. Again, the argument, and it's a good argument, being these are really commercial uses when we have short-term rentals. Why can't we regulate them as a commercial use? And Heath Realty says you look to what the use is, and that is a bunch of people staying in a house. And there's nothing inherent in the concept of housing people in a house that pulls in the element of time. Okay, Makes sense, but in this realm of short-term rentals and the volume of short-term rentals that we see now, and again, the impacts they have, this kind of seems like some stale case law, but it's not. And we still have to use this basis when we're looking at whether a county ordinance is going to be legally sustainable. So again, we're looking at the use and not the length of the occupancy. So that's kind of our threshold question. The 4C case, that is a fascinating case because it looked to um, uh, title restrictions, a deed restriction that addressed commercial use. And the court said, no, a short-term rental, even though there's a prohibition with a deed restriction prohibiting commercial use, a short-term rental is not a commercial use. So sorry, HOA, sorry, neighbors, it's not a commercial use. One idea to I don't want to say get around, but to minimize the impacts of these two cases is to adopt a particular zoning district. And I believe Vila still has theirs on the books. It was a residential lodging district option, and this Acala case did challenge that district, and the court upheld it and said, yeah, it's if you want to have a district that accounts for short-term rentals, but you're still within the realm of that use being housing people, that's okay. So that's a good option. It's a think outside the box option that you may be able to employ. Leah, anything on those? No, okay. Let's see. Other questionable regulations that we advise that you stay clear of. Blanket compliance with commercial building codes. Again, the argument being, hey, you know what? These are commercial uses. We're applying commercial building codes. No, not a good idea. Owner occupancy requirements. Counties and other municipalities have used this as a mechanism to diminish the number of short-term rentals, right, by requiring that the owner be there. Well, that doesn't make a whole lot of sense. If the owner's there, are you going to be renting it to another family? Probably not. So again, these regulations that really don't make a lot of sense, don't seem reasonable, and really the intent is to prohibit people from short-term renting. Those are the problem ones. Specific signage designating the property as a short-term rental. This goes back to Charlie's question, can we have a placard? I have legal concerns with that. And Leah, jump in here if you have anything on that as well. If we limit it to the time that renters are there, if we can narrow the scope, maybe, but just a blanket permanent placard that raises questions. Leah, anything on that point that you want to add?
No, I mean, I just think you're inviting folks to then come onto the property if they know that short-term rentals will have that placard and specifically to, investigate whether there are issues. Neighbors will then know it's there, and that it can cause conflict on the property as well, because it truly acts as an invitation to folks so they can find out the information. So having it registered with the county website so people can look up. That's a totally different thing, so people can look up online, look up the property, maybe even on the GIS map, and can see whether or not there's a short-term rental on a particular property. All of those things are likely okay, but the placard itself on the property, I agree with you, Rebecca, has some concerns.
Great. All right. Last point, what are your requirements for the owner agent or the point of contact? Again, reasonable that you have that requirement, but where are you requiring them to be located? Do they have to be located within 1 mile of the property? Do they or some counties will want to do a time element that the response time has to be within 5 minutes. Well, in many counties, that is just not feasible. So again, look to whether your regulation is reasonable, or does it look like it is just an attempt to deter short-term rentals? Okay. More questionable. Gosh, Malia, we are already at 12:49. I could just talk about this thing for part 3 and part 4.
I could probably talk a lot longer if I didn't have this awful cough.
I know. Goodness, there's just so many elements to short-term rentals. So we'll touch on these, then I want to get into some of the change of laws too. So we know where it might be going, what counties can do. Um, Prohibiting certain rec vehicles. So like you can't have campers, you can't have RVs. The thought being, if you're allowing a camper full of 10 more people, well, that's 10 more people that are going to be using the bathrooms, 10 more people that are going to be using the water resources. Can we basically prohibit that, excessive person count? Um, Again, be careful how you draft it. And a blanket prohibition of no recreational vehicles or campers is probably not going to pass muster. So you're going to have to think a little bit more creatively. That takes us to occupancy, and this truly could be part 3. How do we offset the impacts of short-term rentals? A very obvious option is by limiting occupancy. If we limit the number of people in the property, we're going to limit the impacts of that short-term rental. Problem is, we do not have any clear state law on those occupancy standards. ATCP 72 references the baseline as the size of the sleeping rooms. But when you look at those numbers of how many people are permitted based on size of sleeping rooms, it's a really big number. And many counties feel like, no, that is not a reasonable restriction on occupancy. So what are some other ways that we're looking or that are available to regulate the occupancy? We can look to the number of bedrooms. That's an option that's frequently employed. We can look to the sizing of the septic system. If a property is not on municipal well and sewer or municipal water and sewer, what is the size of their septic system? What is the size? Where is the water supply coming from? And then we look to the DISPUS standards in SPS 383 for how many people, how many occupants can support those systems. So that's another way to regulate, again, to minimize impacts. One option we've seen is a county or counties trying to utilize the hotel room occupancy standards to short-term rentals. And the short answer is those don't work. Hotels will often have like no more than 4 people per room. That does not overlay to a short-term rental house, like a typical, let's say, 1,500 square foot house, can only have four people. They're not apples and oranges, even though, sometimes the argument has been, there's been a good one. And DATCAP has acknowledged too, like, no, that's not the intent of our code. We look to separate keyed entrances as, for hotel rooms, no more than 4 people. Yeah, again, there's no standards and clear standards in state law, which leads us to, are we going to get some clear standards? DATCAP is currently undertaking revisions to ATCP 72 to account for the explosion of short-term rentals in our state. They started this endeavor back in 2023. They had a draft submitted to the legislature in 2020 or in July of 2025. It is now working its way through the legislative process. And the reason I'm not super jazzed is because it really doesn't answer a lot of our key questions, one of which is occupancy. we were really hoping that these revisions to ACTP 72 would give us more definitive guidelines on how counties could regulate occupancy, and they're not there. So we are getting some updates to ATCP 72, but again, in its current form, they're not as helpful as we were hoping they would be. I'll kind of go through these really quickly. Again, there are some changes in ATCP 72 that are helpful, modernizing some of the fire, other building code standards, modernizing the licensing and fee structures, some addressing the annual testing of wells. So we've got some of the natural resource impacts addressed. But again, it doesn't go as far as we were hoping it would go. Again, just more of the updates that we see in the proposed revisions to ATP 72. Again, they haven't been finalized, but it gives you a flavor of what some of the updates are. All right. Occupancy in 7218, the revisions touch on occupancy, but again, it doesn't give us, that definitive answer. So when I say it doesn't talk about occupancy at all, that's not a fair statement. It does touch on occupancy, but again, it doesn't give us the clear answer that we were hoping we would have. That language that's highlighted at the very bottom, or italicized at the very bottom, is nice because it references the regulation by the local government agency, which might be the county. So there is some acknowledgement of a county regulation baked into the revisions to ACTP 72, which is a good thing. And I think that's a win for counties because, again, there's that legal acknowledgement that we as counties can have regulations, and that the state agencies acknowledging that, and then we look to that county regulation as a basis for determining the whichever is less. All right. Again, not included the sizing of the septic system, more clear occupancy elements, and really that fundamental elements of what a county can and can't do. So yeah, we know it's nothing that's inconsistent with state law. Would have been nice to have some more definitive requirements, but we don't have that. So Malia, you and I are still fully employed along with all of our core counsels out there. There will continue to be lots of legal questions regardless of the changes in ATCP 72. Okay, Malia, recent case law. This is exciting because maybe we'll get some better direction than just Heath Realty.
That's kind of where we're at. We did already talk about Wildwood Estates and the Village of Summit earlier in the presentation, so I don't think we'll spend too much time on it. But again, that was the case that said you can't have a zoning ordinance and label it a licensing ordinance and have it apply, because the language in the ordinance looked like a zoning ordinance, smelled like a zoning ordinance, and quacked like a zoning ordinance. It was a zoning ordinance, and because the county didn't go through all of the procedures required to enact a zoning ordinance, it was void. And one of the other things that we know, it's hard on the ground for not only county board supervisors, but zoning administrators and county administrators and administrative coordinators, folks that get the calls from the public that are upset about short-term rentals on their neighbor's property, and upset that every Saturday night there appears to be, I think every party that people complain about, they say there must have been a bachelor party. So it's always been the bachelor party complaints that the short-term rentals get saddled with, and then knowing that the county is limited in its ability. Like, you'll have the public saying, why don't you just ban short-term rentals on my lake? It's ridiculous. They're ruining the lake. It's terrible. Why don't you, county, why don't the supervisors pass an ordinance saying no short-term rentals, and trying to have that conversation about, well, we can't, so we're trying to engage in the limited amount of regulatory authority that we have to ameliorate those, but we're sorry, we can't completely get rid of them. Why don't we go on to the next case
Sure.
on the slides? Because I think we've got 2 minutes left.
Yeah.
Okay, the Wisconsin Realtors Association versus City of Neenah. This case is a recent case, and it had two holdings. One, that the Wisconsin Realtors Association had standing to challenge the City of Neenah's regulation of tourist rooming houses and short-term rentals. And number two, that the ordinance provision that the City of Neenah enacted that said, in order to operate a short-term rental, it has to be your primary residence. And the Court of Appeals said, no, that doesn't make any sense, because that means that any of the other homes that are not primary residences cannot be operated as short-term rental. And they looked at the language of the law, and it said a residential dwelling, not primary residential dwelling. And because of that, they said that regulation was contrary to law. Now, the holding regarding standing was incredibly limited. It wasn't based upon a full review of arguments by either party. In fact, it was only brought up in a cross appeal. And the Court of Appeals said, we're going to assume without deciding that we have jurisdiction to address the standing issue. And we are not going to disturb the circuit court's finding that there was standing. So that jumps us forward to the next case on our slide. Near and dear to my heart.
Yes, ma'am.
This is Wisconsin Realtors Association versus Polk County. Now, I became involved in this case when I was still the corporation counsel for Polk County. And that was over a year ago that I left Polk County. And I'm still working on this case through Attolles law for Polk County, because we're in the Court of Appeals. And in this case, the Wisconsin Realtors Association challenged Polk County's short-term rental ordinances and a whole slew of other ordinances about backlot development with riparian access, a whole bunch of other things. But it also, at the time, Polk County had an ordinance that the short-term rental was a conditional use permit, and they challenged the ordinance, saying it violated the Wisconsin right to rent law. We argued at the circuit court level that they did not have, the Wisconsin Realtors Association did not have what we call associational standing, which is the type of standing when there's an association that has a particular purpose and one of its members would have standing, then the theory goes the association had standing. We argued that they did not have standing, and successfully at the circuit court level. And I will say that the judge made an incredibly reasoned, because it was a very close call, but made a very reasoned and well thought out oral ruling that is now in the Court of Appeals. Now, while this was pending, the City of Neenah decision came out saying, hey, WRA has standing to challenge short-term rentals. And so the Court of Appeals, I was nervous. I thought maybe they would just go, oh, they said they have standing, so they have standing here. And they didn't do that. In fact, they reached out to the attorney for the Wisconsin Realtors Association and to me and said, will you provide supplemental briefing? So we both briefed why this decision should be different than the City of Neenah decision on standing. And now we're waiting for a decision. So I'm not super confident, but you never know. And we put our best foot forward. It would be wonderful for counties if we could limit the litigation ability of Wisconsin realtors, at least when it comes to these types of zoning ordinances. But, you know, we'll see. And I definitely will update everyone once we get that decision from the Court of Appeals.
Awesome. We have one question and then we'll wrap up. I know we're over time here, but Scott Godfrey's got a great question. Even though the law allows a county to prohibit short-term rentals of less than 7 consecutive days, how is that enforceable? Can't an operator simply require a 7-day rental contract for the price of a weekend and the renters leave early? Yes. They absolutely can.
Mhm.
Scott, you're
Yep.
exactly right. And this is most likely occurring. Uh, and so what can a county do? You can, I think it's reasonable to ask for a copy of their standard form contract to see if there is language addressing that 7-day requirement. Um, if it seems to be a pattern, depending on what your ordinance says, ask for those records of past occupants, see if there could be a pattern. But hopefully, first off, it's impossible. You're right, Scott. But hopefully we can work with the owner and come up with a solution that works for everybody. Again, simply to offset the impacts.
And that really is oh, sorry.
No, I was going to say we have one more question, but Malia, go ahead, and then we'll do the last
Well,
question.
I was going to say it becomes incredibly frustrating for zoning administrators because they become the first call of anybody. I think there's different people than were here 2 days ago, and the other people were only here 2 days, so I think they're violating. And it's not like the zoning department has, independent investigation arm that they can send out a private investigator to go try to sort through all of it. And that's frustrating for the public, but it's incredibly frustrating for zoning staff. So know that, it's not only we can put in the regulations, but the enforcement side, we have to be cognizant of what capacity zoning has, just like we do for law enforcement when we're talking about noise ordinance or disorderly conduct ordinance violations. Do they have time to respond to all of them? The same thing, if not more, is true when it comes to the regulations for short-term rentals and the impact on zoning administrators and their staff.
Awesome. The last question is from Ruth Hallstrom, and what a great question. Any legal issues that could arise if a county allows for an ADU, accessory dwelling unit, or second dwelling by right, but requires one dwelling to be owner occupied? I think from a short-term rental standpoint, that makes the owner occupied requirement much more palatable, much more reasonable. However, there is lots of new issues with accessory dwelling units, which I think have trickled to our legislature's attention because of the boom in short-term rentals. And because there's the argument that we have an aging population and your mother-in-law maybe should be able to come and live with you, but in her own separate space. So let's use accessory dwelling units as these additional habitable areas. WCA, Colin Driscoll is working very closely on some proposed legislation that addresses accessory dwelling units and regulations that would go into place on what counties may regulate. And that might be a future in the boardroom or an article in the WCA magazine. Because again, it is a very, very hot topic that, one more thing that stems from the boom in short-term rentals. All right, Malia, any closing comments, closing questions, or closing points?
Be nice to your zoning administrators, run everything by your corporation counsel's office, and we're willing to help.
Perfect.
All right. With that, I want to thank Malia and Rebecca for another extremely educational in the boardroom. Again, just as a reminder, this was recorded, and the PowerPoint slides along with the recording should be up on the WCA website later today. So I want to thank everybody for joining us, and just to remind you that we will be back again on Wednesday, December 17th, where we'll hold the final installment of In the Boardroom for the year. The topic will be Act 12's Innovation Fund and all of the details surrounding the grant program. So we hope to see all of you back here again on December 17th. With that, thank you for joining us, and we hope everybody has a wonderful hunting season as well as a wonderful Thanksgiving.
Bye,
Yes,
everyone.
Holy Week.